Welcome to a whistle-stop tour of the Companies Act 2014. The reason you need to know about it is that it changes and replaces the entire legislative landscape for companies in Ireland. It creates new forms of companies, and it modifies, amends, restricts, and in some cases provides additional rights and obligations to all persons dealing with companies: directors, officers, shareholders, and creditors. Some of the changes will not affect you directly. Many changes will require action by company owners within the 18-month transition period. From the 1st of June 2015, there is an 18-month period for existing companies to elect their designation and to adopt, if necessary, a new constitution. The Constitution essentially replaces what was called the Memorandum and Articles of Association. Because the new Act contains many default provisions and many modernising and efficient ways and means for companies to do business, such as majority written resolutions, it is important that existing companies review their constitutional documents to see if any change is required in order to adapt and fully benefit from the new legislation. Internally, you will need to review your constitution. Externally, you need to select what designation, and we have a table showing the types of companies that are available. If you're a director of a company, then the main change in the legislation is twofold. Firstly, there are now 8 statutory duties of directors which are specified in law and which have evolved from court cases over the last 50-odd years. There is a table of these for illustration. In addition, there are many other duties, some of which are simply replacements from the previous Company Law Acts, and some are new and necessary to protect all parties who deal with companies. Because of these changes, and because of, for example, the creation of 4 types of categories of offence, all of which a director can be held liable for, it is important for anybody who is a director, whether they are an owner, manager, or otherwise, to review the situation and take professional advice on the implementation of the new Act and how it affects you. If you are a company which has or is going to create a charge, there may be changes in the documentation you receive, in certain aspects of the process, the resolutions, and the documentation for creation of a charge. If a company is lending money to its directors, or if a director is lending money to a company, there are important default provisions built in. Any such transaction should be recorded in writing with appropriate advice. In relation to financial statements and the obligations to file financial statements, annual returns and reports, these have all been overhauled. There are certain exemptions, such as the audit exemption, which, while requiring a company to file financial statements, relinquishes them from the obligation to have those financial statements audited. There are a number of default positions in relation to receivers and liquidators. If you're a company that's in difficulty, then the landscape for receivers, liquidators, and insolvency has changed. The duties to cooperate have been increased, and directors are well advised to consider carefully the situation that they are in and take appropriate advice. Thank you for taking the time to view this presentation. We hope it has been of some use to you. If you have any query or wish to obtain some advice, please contact me at the details listed below. Thank you for watching.